Welcome to the legal newsletter program of FDVN. Today's topic is prenuptial property agreement. As the economy increasingly grows, each individual owns huge valuable assets. The development of intellectual property rights, the ownership of shares, and contributed capital affect the demands for possessing private assets, presenting the ownership right of separate assets of spouses. A prenuptial property agreement means that two parties are free to choose a property regime during the marriage within the framework of the law by a written agreement made before getting married. This agreement presents the parties will on the choice of property regime during the marriage. Parties will agree on which property belongs to the wife, which property belongs to the husband, and which property is a joint property of the couple in that written agreement. In the world, there are many different terms to refer to prenuptial property agreements, such as marriage agreement, marriage contract, prenuptial contract, etc., but they are identical in essence. Prenuptial property agreement is a topic providing many matters needed to be discussed. In this video, FDVN would like to convey some of the basic contents of the prenuptial property agreement seen from the historical development of this institution in countries with a long history of legislation around the world, the acceptance of the marriage agreement of Asian countries, the recognition of Vietnamese law in accordance with the current legal regulations. First, let's take a look into marital property agreements in some countries around the world. Marital property agreements in France. France was one of the first countries to recognize the property regime based on the agreement between husband and wife. The recognition of the marriage agreement originated from the principle of freedom of contract and has been admitted since the 16th century, officially recognized in the Napoleonic Code of 1804, today of the French Civil Code. France provides strict regulations on content and form to protect the interests of third parties, social order, and the wife or husband. For the above reasons, a marriage agreement in France is signed freely under control and governed by the provisions of the law. Article 1387 of the Civil Code of France publicizes the principle of free choice of property regime between husband and wife, which is freedom with control. The Civil Code of France recognizes, the law only governs the property relationship between husband and wife when two parties do not regulate specifically related to this matter, as long as that agreement is not contrary to ethics or the following provisions of law. Regarding the content of the agreement, an agreement of spouses cannot violate the obligations and rights arising from marriage relationship, must not violate the rules of parental authority or guardianship, Article 1388. Or limitations prescribed in Article 1389, a spouse's agreement must not prejudice the rights provided for by this law, an agreement of spouses must not terminate or change the order of inheritance according to the law, etc. Therefore, the freedom of spouse to agree on a property regime will be within the legal framework. A collection of rules that must comply with it or these limitations is known as the basic property regime established to maintain public order in the family, etc. Regarding the form of the agreement, Article 1394 of the Civil Code stipulates, all marriage contracts shall be drawn up in notarized writing by a notary public in the presence and consent of all parties to the contract or their authorized persons. Article 1395 of the Civil Code of France stipulates, a marriage contract must be drawn up before marriage and does not come into effect to the date of getting married. To ensure the formal conditions of the contract, the agreement must be presented in writing and made up by a notary public in the presence of the relevant parties. Regarding the validity of the contract, Article 1395 of the Civil Code of France stipulates, a marriage contract must be drawn up before marriage and is not valid until the date of marriage. The validity of a marriage contract arises and depends on a marital relationship and is valid only to the extent that the marriage relationship is maintained. This means that if there is no marriage relationship, the marriage contract will not be valid. Marital property agreements in America. America is known as a country upholding freedom, but in the beginning the U.S. law did not recognize marriage agreement, the freedom to agree on marital property, until around the middle of the 19th century. A number of case laws in the United States allowed the existence of a marriage agreement due to the development of society, and in July 1983, A Marriage Act, Uniform Premarital Agreement Act, UPAA for short, was promulgated based on the results of case laws. UPAA was accepted in 26 U.S. states. Some of the remaining states have different or more special regulations than UPAA. Before the UPPP Marriage Act was issued, the United States had not recognized the marriage agreement with the reason that it destroys marriage. The U.S. has 50 states, and not all states apply a mutual law, so UPAA marriage is applied by most states in the U.S. with some characteristics such as: Regarding the form, the marriage agreement must be in writing and signed by both parties, and no further review of the marriage agreement is required. Accordingly, a marriage agreement in the U.S. only needs to be signed by both parties without the confirmation or witness of another participating party, not requiring the witness of a notary like in France. Although not legally binding as in other countries, the law of the U.S. clearly has stipulated the content of the agreement. Disposal of property upon separation, divorce, death, or disappearance or any other event, change or termination of support between husband and wife, the right to own and transfer from one's life insurance money, the problem of choosing a governing law. Other issues includes personal rights and obligations without violating the law and not contrary to public policy. The right to be supported to their children cannot be adversely affected by marriage agreements. The American law providing obvious provisions on the content of the marriage agreement aims to ensure the interests of the third party, social order, and the spouses themselves. Therefore, although procedures are not too strict, marriage agreements are governed by the content prescribed by the law. Regarding validity, the marriage agreement is valid only during the marriage period. Thus, the marriage contract in the United States is relatively open for spouses to agree on contents. In reality, spouses are also very interested in this regime, which is shown in the fact that many couples are willing to pay a large amount of money to a lawyer to get a legal and tight marriage contract in terms of content and procedure. Marital Property Agreement in Japan. Japan is one of the first Asian countries to recognize the property agreement regime between husband and wife. Reforms under Emperor Meiji had promulgated a civil code based on a draft German civil law providing provisions for the marriage regime inherited by Japanese legislators. However, inheritance is selective and not copied, reflected in the specific features of the marriage regulations in Japan. Through the amendments post-World War II up to now, this code is still valid and effective. A provision recognizing the right to make marriage agreements of spouses is stipulated in Article 755 of the Civil Code. Property rights and obligations of husband and wife must comply with the following regulations if a spouse fails to sign a predetermined contract on their property before marriage registration. Regarding the form of marriage agreement, Japanese legislators have paid great attention to the form of the agreement on the property of spouses, expressed by issuing a legal document to govern the form of marriage agreements and procedures to register marriage agreements. Thus, if spouses want their marriage contract to be recognized and protected by the law, they must comply with provisions in the form of marriage agreements. Regarding the content of marriage agreements, Article 756 of the Civil Code, where spouses have an agreement on their property, in which there are provisions different from the legal property regime, this agreement cannot be against the first-degree heir of wife or husband or a third person unless it is registered before marriage registration. This regulation shows that when a spouse establishes an agreement on the property before registering their marriage, property agreements can exceed the frame as prescribed by the Civil Code, even if that agreement affects the heir's interests of the first-degree heir of the wife or husband or third person, only ensuring that it is registered before registering their marriage. This is a specific point of Japanese law on marital property agreements compared to other countries' laws. Thus, this provision allows spouses to choose between property regime by law or an agreed property regime. In addition, if spouses want to select to apply the property regime under the agreement, it is necessary to make an agreement before marriage registration for the validity of that agreement to be guaranteed. Marital property agreements in Thailand. While Japan is the first Asian country to recognize and codify the marriage contract, Thailand is considered the first Southeast Asian country to admit and apply the property regime agreed upon between husband and wife. The changes in the law come from the uptake of this country. The Civil and Commercial Code was born and passed in 1925 and revised in 2009. The law recognizes the right to enter into a marriage agreement of spouses in Article 1465 of the 1925 Civil and Commercial Code, revised in 2009, in case the husband and wife do not have a special agreement on their property before marriage, their property relations will be governed by the general provisions. Regarding the form of marriage agreement, Article 1466 of the Civil and Commercial Code, a marriage agreement must be registered at the same time registering the marriage, it must be in writing under the witness of at least two people and submitted at the same time of registering marriage. It is a formal condition that spouses must comply with when registering their marriage, regarding the content of the marriage agreement, also specified in Article 1465 of the Civil and Commercial Code. A marriage contract will be void if it contains any provision contrary to public order or social morality or stipulating that their property relations shall be subject to foreign law. Thus, the content of the marriage contract can only be governed by national law and must also comply with the requirements of social morality and public order, then the marriage contract shall be guaranteed by law not to be invalidated. Regulations on change and amendment of marriage contract, Article 1467, after getting married. The marriage agreement shall not be adjusted unless approved by the competent court, and when there is a final decision on the modification or annulment of the marriage contract, the court must notify the place of marriage registration about that matter. Accordingly, the marriage contract can only be changed when the court accepts, but some provisions of the marriage contract will not be valid for a third party in good faith, bona fide third party. Thus, it can be seen that the regulations on the content, form, and change and modification of the marriage contract are quite detailed, specific, and tight. This helps legislators improve their management ability, also helps to reduce injustice in society, and prevents the abuse of marriage contracts for personal gain or to avoid obligations. Marital property agreements in China, like most socialist countries, before the 2001 marriage law took effect, China did not recognize the property regime under the agreement of husband and wife. In 2001, the marriage law of China added new provisions related to pre-marriage or marriage agreements. Article 19 states, the spouses may, by agreement, assess the property of each party before and after the marriage. Regarding the form of marriage agreement, all these agreements must be in writing. Regarding the content of the marriage agreement, the husband and wife can choose to apply the property ownership regime, either jointly owning the whole thing, owning a part, or owning it separately. If this agreement is unclear or lacking, regulations on ownership regime between husband and wife according to law shall be applied. As such, Chinese law allows couples to choose between legal or contractual property regimes. When the agreed-upon property regime is selected, but the content conditions are not satisfied, the legal property regime is automatically applied. Thus, Chinese law still exists two property regimes between husband and wife, including the legal property regime and the agreed-upon property regime. 2. Vietnamese law provisions on the agreed-upon property regime between wife and husband. In Vietnam, before the 2014 law on marriage and family came into effect, the agreed-upon property regime between wife and husband had not been recognized. The law on marriage and family 2000 only recognized the property regime provided by law. The property regime under the premarital agreement recognized by Vietnamese law is the result of the process of social recognition and selective absorption of the spirit of free agreement on the property from countries around the world. Accordingly, Vietnamese law has provisions on agreement on the property regime between husband and wife as follows. First, regarding the content of the agreement, in case the two married parties choose the agreed-upon property regime, this agreement must be made before the marriage registration, and the husband and wife may agree on the determination of property according to one of the following contents. Property between husband and wife includes common property and separate property of husband and wife. There is no separate property between husband and wife, but all property acquired by husband and wife before marriage or during marriage period is under common property. There is no common property between husband and wife, but all property acquired by husband and wife before marriage and during the marriage period belongs to the person owning such property, be determined by other agreement of husband and wife. Agreement on property must be in accordance with the law on general principles of the matrimonial property regime, Article 29. Rights and obligations of husband and wife to meet their family's essential needs, Article 30, transactions related to the home being the sole domicile of husband and wife, Article 31, and transactions with third parties in good faith related to bank accounts, securities accounts and other movable assets not required by law to be registered for ownership and use. Second, regarding the form of the agreement, Article 47 of the Law on Family Marriage 2014 clearly stipulates that the agreement to establish the property regime between the husband and wife must be made in writing, be notarized, and authenticated. The property regime between husband and wife under the agreement is established from the date of marriage registration. Third, on the amendment and supplementation of the content of the property regime between husband and wife, in case the agreed-upon property regime is applied. During the marriage period, the husband and wife have the right to agree to amend or supplement part or all of the content of that property regime or apply the statutory property regime. Agreements to amend and supplement the content of the spouse's property regime must be notarized or authenticated in accordance with the law. The agreement to amend and supplement the content of the husband and wife's property regime takes effect from the date it is notarized or authenticated. Property rights and obligations arising before the effective date of the amendment or supplement to the husband and wife's property regime are still valid unless otherwise agreed upon by the parties. Fourth, the obligation to provide information on the agreed-upon property regime in transactions with third parties, Article 16 of Decree No. 126/2014/NDCP, in case of applying the agreed matrimonial property regime, when establishing and making a transaction, a spouse shall provide a third party with relevant information. If a spouse fails to perform this obligation, the third party shall be regarded as acting in good faith and have its interests protected in accordance with the Civil Code. Fifth, note the cases in which the agreement on the husband and wife's property regime is invalidated. The law allows the parties to self-choose the property regime and provides provisions on the contents that the parties can agree. However, such an agreement must be within the framework of the law. Therefore, the agreement on the husband and wife's property regime is declared invalid by the court when it falls into one of the cases specified in Article 50 of the Law on Marriage and Family 2014 and Clause 2. Article 6 TTLT 01/2016/TTLT 10 VKSNDTC, BTP, specifically as follows: Case 1. It fails to meet the conditions on effect of transactions prescribed the Civil Code and other relevant laws, conditions for effective. 3. When the performance of property rights and obligations of husband and wife infringes upon lawful rights and interests of the wife, husband, their family or other persons, compensation shall be paid. Accordingly, the agreement on the property of husband and wife will be invalid if it infringes upon the legitimate rights and interests of the parties, their families, and other people. 2. Violating obligations of husband and wife to meet their family's essential needs as prescribed in Article 30 of the Law on Marriage and Family. Article 30. Rights and obligations of husband and wife to meet their family's essential needs. 1. Husband and wife have the right and obligation to make transactions to meet their family's essential needs. 2. When husband and wife have no common property or their common property is not enough to meet their family's essential needs, they shall contribute their separate property according to their financial capacity. Accordingly, the property agreement of husband and wife must ensure the obligation to meet the essential needs of the family. Moreover, property agreements that aim to evade the obligation of each party to contribute their own share of the property to meet the common necessities of the family are also considered void. 3. Violating the rights related to the home being the sole domicile of husband and wife, Article 31. Transactions related to the home being the sole domicile of husband and wife, the establishment, making and termination of transactions related to the home being the sole domicile of husband and wife shall be agreed by both of them. In case the home is under the separate ownership of the husband or wife, the owner has the right to establish, make and terminate transactions related to that property but shall ensure domicile for the couple. 4. Violating the provisions providing information on the agreed matrimonial property regime in transactions with third parties specified in Article 32 is guided in Article 16 of Decree 126/2014/NDCP guiding the implementation of the law on marriage and family, Article 16. Provision of information on the agreed matrimonial property regime in transactions with third parties, in case of applying the agreed matrimonial property regime, when establishing and making a transaction. A spouse shall provide a third party with relevant information. If a spouse fails to perform this obligation, the third party shall be regarded as acting in good faith and have its interests protected in accordance with the Civil Code. In particular, invalid agreements on the property regime between husband and wife due to the violation of the right to be guaranteed accommodation of spouses as prescribed in Article 31 and Point B, Clause 1, Article 50 of the Law on Marriage and Family are agreements that allow one party to have the right to dispose of the house as the sole residence of the husband and wife, resulting in the husband or wife having no place to live or not ensuring the minimum accommodation in terms of area, living conditions, and safety, environmental sanitation under the law on housing. Case 3. Its contents seriously infringe upon the rights to be supported and inherit and other lawful rights and interests of parents, children, and other family members. It means that the content of the agreement aims to evade the support obligation specified in Articles 110 to 115 of the Law on Marriage and Family or to deprive the heirs of the inheritance rights regardless of the content of the will in accordance with the Civil Code or violate the lawful rights and interests of parents, children, and other family members as prescribed by the Law on Marriage and Family and other relevant laws. For example, Example 1. Mr. A is obligated to support Mr. B. Mr. A then married Mrs. C and agreed to transfer all his assets to Mrs. C, therefore, there is no property left to fulfill the support obligation for Mr. B. In this case, the agreement on property between Mr. A and Mrs. C is void. Example 2, Mr. A has an adult child but is unable to work. Then, Mr. A married Ms. B. Mr. A and Ms. B agreed to establish a property regime between wife and husband, including the content that all of Mr. A's assets will be inherited by Ms. B when Mr. A dies. In this case, the content of the agreement on the property regime between Mr. A and Ms. B is invalid for the part of Mr. A's property that the son who has lost her civil act capacity will inherit according to the provisions of law. When an agreement on the husband and wife's property regime falls into the above case, the following subjects have the right to request the court to declare the agreement on the husband and wife's property regime invalid. A. Wife, husband, or spouses have agreed on the property regime. B. The infringed person, the guardian of the person whose lawful rights and interests are infringed due to an agreement on the property regime of the spouses, the order and procedures for settling a request. For the court to declare that the agreement on the husband and wife's property regime is invalid shall comply with the provisions of the Civil Procedure Law. A. In case the agreement on the husband and wife's property regime is declared completely invalid by the court, the statutory property regime of the husband and wife shall be applied. B. In case the agreement on the husband and wife's property regime is declared partially invalid, the contents that are not invalidated shall still be applied. For the invalid content, the corresponding provisions on the statutory property regime of husband and wife shall be applied. Above are the basic contents of the property regime under the agreement of husband and wife from the perspective of the legal regulations of countries around the world and the laws of Vietnam, which are researched, edited, and performed by FDVN lawyers. We hope that this content will partially support your legal knowledge and those of you who are interested in this issue. For now, the legal news program of FDVN Lawyers for today is coming to an end. Thanks for watching and see you in the next program on FDVN Lawyer channel.